Rautin and Foster, but as indicated, Advocate Foster will be with Justice Shongwe for a bit and will join us in due course.
Thank you very much.
May it please the Court, Justice Pistorius, I appear on behalf of the respondent, and I'm assisted by Ms. Jackson and Ms. Adams, and the other person, Ms. Malope, unfortunately could not make it. We apologize for that.
Thank you, Mr. Hu. I think it's appropriate that I should offer our apologies for him starting a little bit late. There was some small problem that you were sorting out, but I hope you accept our apologies for that. Are you ready, Ms. Johnson?
As the Court pleases, Justice Bosiela. At the outset, if I might add that with regards to aspects of the condemnation, both the appellants and the respondents have reached an agreement that that is not an issue. So we will not belabor this court with any arguments about condemnations. If I may then...
that, Mr. Hu, sorry?
I agree with that. Thank you,
very
Justice
much.
Bosiela.
Condemnation granted.
In keeping there with justices, I do not wish to belabor the court record with lengthy argument. I am sure the court and all the justices have gone through the relevant records. Safe to say, we then wish to highlight certain aspects with regards to the application for leave to appeal in terms of the test to be applied, and obviously then the reasons why we say that leave to be granted and should it be granted. What in fact we expect of this court.
Can I interrupt you? We're sitting with two instances here. The first is the application for leave to appeal, and if you are inclined to grant it, then we can deal with the merits.
As the court pleases.
Prima facie suggests that they should all be done separately, one before the other one, because we cannot anticipate that leave is going to be granted. But at a practical level, it wouldn't work. Would it be acceptable to both counsel if we listen to both instances at the same time? When you argue application for leave to appeal, at the same time you argue the merits.
That is most acceptable, Justice Bosiela, because that is in fact how both the appellants and the respondent have prepared, so that the arguments may in fact interlock with one another, so that the court at the end has a holistic view of what it is the application is about and which grounds we rely on in terms of elevating it to that status. So we are prepared to argue it that way, and we are indebted to the court because it then makes the application somewhat easier.
Are you ready to proceed?
I'm ready to proceed. This is an application for leave to appeal by the state against the sentence of 6 years imprisonment, which was handed down by the quota quo. And the background for the application is set out in our founding papers quite at length, and so we do not intend going through the heads of argument at length. And so at the outset, I respectfully submit, Justices, that the central question, and indeed the test in the present application, is whether there are reasonable prospects of success on appeal. To this end, I wish to refer to the court to the matter of State versus Smith, 2012, Volume 1.
Can I say for your age? State versus Smith and versus Tonkin are judgment of this court.
As the court
pleases. What I say, what principle.
So in keeping with that principle, the state then wishes to just highlight that this honorable court, having held that the phrase reasonable prospects of success postulates a dispassionate decision based on the facts and the law, and that a court of appeal could reasonably arrive at a conclusion different to that of the trial court. And thus the test is whether an appellate court may reasonably, not would, may reasonably arrive at a conclusion different to the quota quo. And in this regard, if you would indulge me, Justice Bosielo, just to show that in terms of the interpretation or definition of misdirection, it is rather a simple definition. And I think perhaps we err when we look for grounds that seem to be somewhat in-depth. It is a simple test. And the definition is to be found in the matter of the State versus Pillay.
State versus Pillay, State versus Rabi, all cases on an appeal against a sentence say Court of Appeal should be aware of the fact that the discretion to impose a sentence is preeminently in the trial court.
Yes, it is.
So it's not as if we have a carte blanche to interfere with the sentence. Our powers to interfere are circumscribed. I want you to start from there.
And in your powers being circumscribed, Justice Bosielo, it goes to the heart of not just the reasonable prospect of success, but in looking at the misdirection. And the misdirection must not just be material, but it should be an error. It is a rather simple test. And so in Pillay we say, now the word misdirection in the present context simply means an error committed by the court in determining or applying the facts for assessing the appropriate sentence. It must, Justice Bosielo, be of such a nature, degree, or seriousness that it shows directly or inferentially that the court did not exercise its discretion at all or exercised it improperly or unreasonably. And what we say to this court is that the court exercised its discretion inappropriately, that the sentence that was arrived at as a result of the misdirections which we have set out at length, and those misdirections are material. They've led to the irregularity, and the irregularity is that the court then arrived at an unjust sentence.
Are you able to tell us where exactly did Judge Masipa misdirect herself? I read her judgment on sentence, very material judgment. She started the personal particulars, she goes to the nature of the crime, she's done that, said it out like she's talking to law students.
As the court pleases.
And look at all the facts holistically in terms of state versus Zim.
As the court pleases.
Where did she err?
She erred in the following aspects. When the court sentenced the respondent in the matter, the court ignored, in our submission, key material findings of this court's judgment when this court found the respondent guilty of murder dolus eventualis. And in so doing, we say that some of the aspects is that the court firstly regarded the respondent's belief that there was an intruder in the house as a mitigating factor. And this is found in this honorable court's judgment at paragraph 53. And in rejecting the respondent's version of putative private defense, that when the respondent testified at trial, he stated that he had not intended to shoot the person whom he felt was an intruder, and further that his evidence is so contradictory that one does just not know his true explanation for firing the weapon. Secondly, the court regarded the respondent's purported or alleged feelings of vulnerability and anxiety.
But can I interrupt you? She deals with that in her judgment. Look at page 423. She acknowledges the circumstances in this matter have changed, as the accused has now been found guilty of murder dolus eventualis, which is a more serious offense than culpable homicide. She deals with that.
It is so. I'm not saying, Justice Bosielo, that she did not consider the judgment of this court at all. Our argument is simply this, that in certain aspects...
I ask a question. In her judgment that we have to take on appeal, where did she err?
And that's
maybe just to follow up on Judge Busielo's question. I look at the judgment, and Judge Masipa seems to talk about remorse. Are you in a position to address us on that?
As the court pleases. With regards the aspect of remorse, we found that the court found that the respondent had genuine remorse. However, it is clear from this honorable court's judgment that an essential ingredient for genuine remorse is missing, namely a reason from the respondent for firing the 4 fatal shots. On 3 pertinent occasions, this honorable court, in its appeal judgment at paragraphs 17, 49, and 53.
What did Mr. Pistorius do to try and show remorse?
As the court pleases, he said, I am sorry.
He made various attempts to talk to the family. He apologized publicly in court.
As the court pleases.
The same comes with me. He tried to talk to them and they refused to talk to him. What more could he have done?
It is so. One does not say, he is not saying that he is sorry, but one cannot elevate his regret and his sympathy to that of remorse. The test for remorse...
Is it not a semantic, or leading us into a semantic cobweb? The man stands in open because I apologize. I did something very horrible. He tries to communicate with the family. How do you verbalize your remorse?
Taking the court into his confidence.
He did. He apologized before the trial started in court. He did.
As a court pleases.
It's there on record.
My submission in that regard, Justice Bosielo, is simply that in so doing, yes, there is those verbal apologies, but without more without more. That is not genuine remorse.
What
And
more?
what I'm
What
saying
more should
is
he have
that
done? I'm interested. What more should he have done?
for me, he should have taken the court into his confidence, and even if he didn't, when he had the opportunity in his consultations with Professor Scholes, what he could and ought to have done was said, okay,
Don't you
the
want
court
to
has
leave that
found
to
me
us to
guilty of
evaluate that
murder.
evidence because it's on record?
As the court pleases, it's simply but to say that in so doing, he should have taken the confidence of the court and said, this is why I did it. That is what we want him to say. This is why I did it.
Still
Because
on
with
that
nothing more severity, then there is no true, genuine, gut-wrenching remorse.
Do you want to comment about the judgment of this court in State versus Machichi, where the court talks about genuine remorse?
As the court pleases.
And try and contrast with what Professor Scholes said in his report. Professor Scholes said something to the effect that it indicates that the accused explains that he fails to identify himself as having committed a crime, as his intentions were to protect the victim. One, this statement seems to suggest that in his view, he has not committed a crime, he's trying to protect the victim. Two, this court, when it dealt with the question of the conviction, ended up saying that this court does not even know what his explanation is for having shot 4 bullets.
As the court pleases.
Then from there, this matter goes back to the trial court. Despite what this court has said, Mr. Pistorius decides not to testify. Are we in a better position than we were at the time when this matter was heard? Do we know why he shot those 4 bullets?
To date, Justice Severity, we have no explanation. And if I may then deal with that aspect, as well as Machichi's matter, as well as the aspect of remorse. We deal with it as being a material misdirection. And we say, the Honorable Court in State versus Machichi, at paragraph 13, laid down the criteria for, or perhaps as we say, the elements of genuine remorse, as opposed to merely feeling sorry for oneself and regretting one's actions. Firstly, the court held that genuine contrition can only come from an appreciation and acknowledgement of the extent of one's error. The respondent in the present matter has never shown this. All that he says is he is sorry for and accepts the mistake or accident of having taken the life of the deceased. He does not say, Justice Siri, that he is sorry for having intentionally caused the death of the deceased. And that is where we still sit. This is where we left this court with a judgment, and to date, no explanation. And that is the point I was trying to make to Justice Bosiello, is to say, yes, he says he's sorry, but his true contrition, he had a second opportunity. So whilst initially in the quota quo, he felt justified not to say anything, this court finds him guilty of murder, but pertinently says, we do not have an explanation. When you then reconsider as the respondent such a finding by the court, one would automatically expect some kind of explanation. Perhaps also in addition, is not just an explanation, because what the respondent does, Justice Seriti, is he doesn't just not only not offer an explanation, he gives the impression during the sentencing proceedings that, okay, this is what the SCA says. Well, I guess I have no choice. I'll make peace with it. But that is not remorse. That is not showing the court that I take into account your findings. Let me then take you into my confidence. And in as much as he was overwhelmed and didn't want to perhaps testify in the sentencing proceedings, he had Professor Scholes. He was prepared for Professor Scholes to come and tell us about the 2 Oscars, about how he suffered. But could he at the very least have told us how and or why the offense was committed? And so he does not say he is sorry for having intentionally caused the death of the deceased. This is a finding of the court. This court did not say, Mr. Pistorius, we accept your mistake or your accident. When this court remitted the judgment for sentence, it said, take into consideration all the findings of. And one of the findings was, after having fired those 4 shots with a high caliber weapon, lethal ammunition, there was no explanation. And unfortunately, Justice Severity, where we are today, we still have no explanation. And so, in fact, Professor Scholes, when he testified for the defense in mitigation of sentence, indicated that the respondent took the life of the deceased without intending to do so. Moreover, the respondent's version is, I did not intend to shoot anyone or the intruder. Professor Scholes also testified that he did not discuss with the respondent this honorable court's finding that one really does not know what his explanation is for having fired the fatal shots. And perhaps, if I may, just as a further, it also emerged, Justice Severity, in Professor Scholes' evidence, Mrs. Bai was a prison official and the counseling psychologist at Correctional Services, in an interview with the respondent in prison, and this was when he had initially been sentenced. And she said, Mr. Pistorius explains that he fails to identify himself as having committed the crime, as his intentions were to protect the victim. We do not have anything else. We haven't gone further than where we are at. And that is what I mean, Justice Bosielo, that this is where the quote unquote erred. She elevated his regret. And one cannot say that his regret absolves him of the crime and cannot elevate it to remorse without more from the respondent. If we then go to Matiti, Justice Severity, for me to complete that argument and that it would deal with all the aspects of remorse so that I do not have to come back to it. At page 47 and paragraph 13, and I read, there is moreover a chasm between regret and remorse. Many accused persons might well regret their conduct, as we say was the case with this respondent, but that does not without more translate to genuine remorse. Thus, genuine contrition can only come from an appreciation and acknowledgement of the extent of one's error. If we look at what he said to Ms. Bai, if we look at the fact that he had ample opportunity, even after this court's finding, to take someone into his confidence and say why he did what he did. Whether the offender is sincerely remorseful and not simply feeling sorry for himself or herself at having been caught is a factual question. It is to the surrounding actions of the accused rather than what he says in court that one should rather look at. And yes, Justice Bosielo, that is the question. What could he do more than say he was sorry? I go then back to that point. In doing more, he was to come to the court and take the court into his confidence.
Thank you. I think you've made your point. Can you go to the next misdirection?
So we say, Justice Bosielo, that first we dealt with the fact that the quota quo took the fact that, in the court's view, the fact that the respondents believed that there was an intruder is a mitigating fact. Because this court held at paragraph 54 of the judgment that the respondent failed to establish at least a factual foundation for his alleged genuine belief.
Can you help us to follow your argument? We have three judgments here. The judgment of court of
so the judgment of this court.
Indicate which judgment you're referring to.
As the court pleases. If we refer to the judgment of this court, and if I could perhaps go a step back and say, moreover, this honorable court in paragraph 15.
Which paragraph?
In paragraph 53, Justice Severity, of this court's judgment, when the court handed out judgment in convicting him of murder. 5.3, as a court pleases, we say that this honorable court, in the same paragraph, added that not only did the respondent not know who was behind the door, he also did not know whether that person in fact constituted any threat to him. This honorable court held, or proceeded to hold, that in these circumstances, it is inconceivable that the respondent could have believed he was entitled to fire at this person with a heavy caliber firearm without taking even that most elementary precaution of firing a warning shot. And this honorable court in its judgment at paragraph 54 proceeded to add and held that the respondent failed to establish at least a factual foundation for his alleged genuine belief of an imminent attack upon him. And the simple argument thus is that is a misdirection. This court made a finding. For the court, a quote, to now say that the respondents believe that there was an intruder in the house is a mitigating factor goes against the findings of this court. We say the second misdirection is that the court regarded the respondent's purported or alleged feelings of vulnerability and anxiety when he is on his stumps as a mitigating factor. And I would like to pause and to point the court to its own judgment. And we start again at paragraph 54, Justice Posiello, the judgment of this court. We will be going through paragraphs 54, 53, and 49, Justices. At paragraph 54, this court held, although frightened, the accused armed himself to shoot if there was someone in the bathroom, and when there was, he did. At paragraph 53, this court held, although he, that is the respondent, may have been anxious, it is inconceivable that a rational person could have believed he was entitled to fire at this person with a heavy caliber firearm without...
We are reading paragraph 53.
53.
Which line? At the bottom. Right at the bottom.
At the bottom, as the court pleases.
Thank you.
Believed he was entitled, Justice Severity, to fire at this person with a heavy caliber firearm without taking even that most elementary precaution of firing a warning. At paragraph 49, the same judgment. On his own version, when he thought there was an intruder in the toilet, the accused armed himself with a heavy caliber firearm, loaded with ammunition, specifically designed for self-defense, screamed at the intruder to get out of the house, and proceeded to the bathroom in order to confront whoever might be there. He is a person well trained in the use of firearms and was holding his weapon at the ready in order to shoot. He paused at the entrance to the bathroom, and when he became aware that there was a person in the toilet cubicle, he fired 4 shots through the door. And yes, Justice Severity, as per this court's judgment, and he never, still hasn't, offered an acceptable explanation for having done so. And so, at paragraph 11 of the same judgment, this honorable court pointed out that this paragraph 11, 1-1, Justice Severity.
Yes, you may proceed.
As the court pleases, this honorable court pointed out that despite the disability of the respondent, he overcame much.
Wait a minute. It's very difficult for you. You don't draw attention to a particular sentence where you sometimes you quote in the middle of a very long paragraph. Which line of paragraph 11 you quoting from?
Court would. It is towards the end of paragraph 11 of the judgment, where the summation of that paragraph is that this court pointed out that despite the disability of the respondent, Justice Posiello, he overcame much and excelled in life after having become inter alia a Paralympian champion on the world stage and also represented South Africa in the able-bodied Olympics of 2012. So those are the two misdirections in terms of what we say the court failed to take into account in terms of the findings of this court's judgment. Third aspect, when we look at the issue of dolus eventualis, we say, Justice Posiello, that the dolus eventualis, in as much as the respondent was found guilty of murder dolus eventualis, the dolus eventualis was indeed of a gross nature. And to that end, I referred this court to its judgment at paragraph 50. At line 1. Line 1.
Okay.
And I read, as a matter of common sense, at the time the fatal shots were fired, the possibility of the death of the person behind the door was clearly an obvious result. And in firing not 1, but 4 shots, such a result became even more likely. But that is exactly what the accused did. That's 1, 2, 3.
Can I ask
The
a
second,
following question?
as a court basis.
The Criminal Law Amendment Act, Act 105 of 1997, requires that when a sentencing judge considers the presence or otherwise of substantial and compelling circumstances as required in Section 51(3), those facts must be tabulated.
As the court pleases.
Do we have that on the record?
And that is the predicament the appellants sit with. We're safe to argue that we do not see the presence of substantial and compelling factors. It makes it rather difficult to argue whether or not there in fact were substantial and compelling factors simply because they were not noted. So I cannot say, justices, that, well, maybe there could have been. Perhaps if the judge, as is expected in the prescripts of the law, if the court had noted the substantial and compelling factors, I may then have been able to address the court and say, I hear the court. Perhaps reason one might be, might not be, but in the absence.
The easy way to do it is we should have had a list of aggravated circumstances, compare and contrast the list of so-called substantial and compelling, and make a very judgment. Are they weighty enough to justify departure from minimum sentence? We're not able to do that.
No. And I think, Justice Posiello, the predicament is, in order to have first noted the substantial and compelling circumstances, we say we cannot address this court about what they were because we do not agree that the mitigating factors led at the court are of substance to elevate them to the status of substantial and compelling. What we're saying is the reasons furnished for mitigation, the mitigating factors are nothing but that, mitigating. In order for the court to have deviated, the court ought first not just to have listed, but to have said, if I say this is a substantial and compelling factor, I say so for the following reasons, and this is the substance attached. So we don't have that. So what we have is a court saying substantial and compelling factors are present. Which are they? Which of those mitigating factors? And so we say that in terms of the law, in terms of the Act, the court ought to have started, first listed the substantial and compelling factors, then said, because of their presence, I now deviate from the minimum sentences. In deviating, I then say that these are some of the mitigating factors that will allow me to lessen the sentence from 15, taking into account his time in incarceration. Tongue-in-cheek, I say, maybe she could have said, probably we're at 13, but the court does not have a clean slate. The court does not have a clean slate from which he departs, and that is the problem.
I'm trying to suggest that the period that he spent in detention or in prison prior to this court having made a decision about the merits, is that one of the factors that must be taken into account in order to determine whether there are substantial and compelling circumstances?
No. I'm saying if the court thought, because we don't have anything, Justice Severity. And so what I'm saying is if I had to put myself in the same shoes as the court and gave such reasons, then we could have said what the deviation was. But there was no reasoning, and that is where the court as well erred. So we don't have substantial and compelling circumstances would justify the imposition of a lesser sentence. And Justice Posiello, if you would allow me, while we're on that aspect, if I could just address the court then on the substantial and compelling circumstances aspect.
Certainly.
Our position is as follows. There are no substantial and compelling circumstances which justify the imposition of a lesser sentence, and the court materially misdirected itself in finding that there are. The starting point is the minimum prescribed sentence of 15 years imprisonment. It is no longer business as usual. And if I may pause, in the matter of the State versus Malchus, at paragraphs 7 and 8, the very last two lines of paragraph 7, which is end of paragraph F, getting into G, and I state, that it was no longer to be business as usual when sentencing for the commission of the specified crimes. In what respects was it no longer to be business as usual? First, a court was not given a clean slate on which to inscribe whatever sentence it thought fit justices. Instead, it was required to approach that question conscious of the fact that the legislature had ordained life imprisonment or the particular prescribed period of imprisonment as the sentence which should ordinarily be imposed for the commission of the listed crimes in the specified circumstances. In short, justices, the legislature aimed at ensuring a severe, standardized, and consistent response from the courts to the commission of such crimes unless there were, and could be seen to be, truly convincing reasons for a different response. And when considering this sentence, the emphasis was to be shifted to the objective gravity of the type of crime and the public's need for effective sanctions against it. We do not have that. So the court was not given a clean slate. It was not to be business as usual. Sentence served analogous to time spent in custody, Justice Severity. This Honourable Court's decision in the State versus Khadebe and another at paragraphs 13 and 14.
What is the full citation?
Sorry, Justice.
What is the full citation of Khadebe?
As a State versus Khadebe, 2013, Volume 2, the South African Criminal Law Reports at 165. I read from 169, paragraph 13. And this court had held that a mechanical formula to determine the extent to which the proposed sentence should be reduced by reason of the period of detention prior to conviction is unhelpful. The circumstances of an individual accused must be assessed in each case in determining the extent to which the sentence proposed should be reduced. Paragraph 14 on page 170 of the judgment, a better approach in my view is that the period in detention pre-sentencing is but one of the factors that should be taken into account in determining whether the effective period of imprisonment to be imposed is justified, whether it is proportionate to the crime.
Stop you there? Doesn't that suggest that what the court should have done was, let me look at the circumstances. Do I find substantial compelling circumstances to permit me to deviate from the 15-year period? Assuming the court says no. Then the court go further and say, but this man served 3 years in prison. What do I do with it? Is he getting credit for it? Would that be a proper approach in this matter?
The court could have given him credit.
Okay.
But only if the court made the relevant finding.
But the court should have started by saying, this is an offense that calls for a minimum of not less than 15.
As the court pleases.
I have not found substantial compelling to change. However, the reality is he's already spent 3 years. He will have credit for that. So it's 15 years, take account 3 years, whatever it is, and then we get the exact sentence.
I follow the argument, but it doesn't necessarily go to 15, let's take away 3. He was incarcerated for 12 months.
No, whatever it was, can we ignore?
No.
Whatever time that he spent.
But in the absence of noting, then taking these as, and I think that is the challenge. The challenge is when you do not note what substantial and compelling are, but in the judgment, you would want us to perceive that his personal circumstances, his feelings of vulnerability and anxiety, as well as the time spent.
You're answering a different question. I assume that we've gone through that.
Yes.
We have found that they're not substantial enough to deviate from 15. You say you should have 15 years. But however, we are aware that you already spent 12 months. How do we do with 12 months? You got a 15, less 12 months, this is a sentence you are going to serve.
As the court pleases.
We have confirmed the principle of no deviation without weighty considerations from the minimum sentence.
As the court pleases.
Ms. Johnson, isn't another way to deal with that issue? That part of a sentence that is already served in jail by predating the judgment or the sentence.
In other words, antedated the judgment to the date on which the first sentence was imposed. Will that not deal with all those problems? If we come to the conclusion that there are no substantial and compelling circumstances.
But only if. You see, for me, it's a matter of, it's only, She did not find them to be substantial and compelling.
Just listen to the question. Just listen to the proposition. If we do find that there are no substantial and compelling circumstances, then we're back to 51(2).
Yes.
In that case, in order to deal with the problems of the period that is served prior to the sentencing, will it not be easy to deal with that issue by antedating the sentence that we are going to give?
No. You see, when he served his term of imprisonment, it was on the findings of culpable homicide of the quota quo. We say now...
No, but that has been set aside.
Yes.
Recognition must be given to him for the time that he had already spent in custody.
As a court pleases, and it
That is just logic.
As a court pleases, and it goes back to the points that were raised by Justice Bosiello.
Can I make it easy for you? Isn't the best solution to say, well, I acknowledge that you can't ignore the period that is served in jail. But I leave that to the court, how the mechanism, how it's for you to decide.
As a court pleases. And so without belaboring the point that there are no substantial and compelling reasons, they have not been noted. The matter of Malchus makes it very clear.
Can I draw your attention to the judgment on sentence by Judge Masipa? I think it appears on page 4017. She does make an attempt to identify what she thought were page 4017.
As a court pleases, I am there.
Page 4017.
4017, I am there, Justice Bosiello.
The heading is mitigating factors. The mitigating factors are the following. You have it?
I have it, Justice.
The first one, she still goes back to that belief that was there. The second one is that he didn't have his processes and therefore he felt vulnerable. Third one is the belief that was intruded in your house.
Yes.
And his alleged behavior after he realized what had happened to the deceased, what the evidence of Dr. Steep. Then she talks about apologizing. And that's about it. And at the end of that long paragraph at 419, she says the following: I've taken all the above into consideration, and I'm of the view that mitigating circumstances outweigh the aggravating circumstances. I find that there are substantial and compelling circumstances that justify deviation from imposition of the prescribed sentence of 15 years. I will ask the question in the following manner: assuming we find that these are the factors before, do they qualify in terms of the long list of cases from various courts, and this court in particular? Can they be elevated to a point where we can say they are weight enough to have justified a departure from the sentence that is ordained, using the language of Malchus, from 15 years to 6 years?
With all due respect, Justice Bosiello, no, it does not. It does not. I can take it no further than to say it does not, because it goes back to what was held in Malchus, as well as the general prescripts. And also to say that these are not factors that have never been taken into consideration as mitigating factors over the years by the courts, including the time served. So there is no substance to elevate any of those on pages 4017 till 4019 and say, these are mitigating. I find that they are substantial and compelling factors.
In other words, what the judge has enumerated as mitigating factors, these are ordinary mitigating factors.
As the court pleases.
And in terms of Malchus, when you consider sentence, the traditional factors must also be taken into account. But it doesn't necessarily mean that those traditional factors are substantial and compelling circumstances.
It is so, Justice Severity, because on any given day, in any given court, from the court of quo, whether they're regional or district or high courts, those are the factors that are enunciated by the respective accused and or respondents. in lieu of sentence. And that is what the courts do on a daily basis. So the quota quo did not give us more other than what already was and should have been taken into account.
But that doesn't mean that they can't be considered. But I mean, Malha says that. So traditional personal circumstances take into account. The test is whether they're weight enough, either individually or cumulatively.
As the court pleases, and I agree, there was no substance and weight to be attached in order to elevate them. And that is where we say, justices, that she misdirected herself. We also then say, in terms of the misdirections, I have dealt with the issue of remorse. If I could deal with a material misdirection in terms of her failure to grade the degree of foreseeability and furnish just a rather simple argument, I am not taking this court to your dolus eventualis should have been dolus directus. That is not where the appellant is going.
I don't want to enter into that. This court has finally decided that.
That is it. And this is the argument I then propose in terms of, and submit in terms of the weight to be attached to that form of intention in grading that degree of foreseeability. We say...
I'll tell you what my concern is. I'm sorry to interrupt you.
As a court, please.
We have dealt with the circumstances that Judge Masita enumerated. Now, as against that, on the same page, she deals with aggravating circumstances.
As a court, please.
But insofar as I'm concerned with the following. We now know what happened. Having read the record, I'm still at a loss as to whether the respondent gave a reason why he shot. There are so many explanations. But it goes to the nature of the offense and the gravity of the offense. And I ask myself, I'm interested to know, why did he shoot 4 times? Not once, not twice, not thrice, but 4 times. And this is a lethal weapon. When you put them on the scale, what did they do on the scale?
And that is where and that is the point I intend to make in this aspect, is it wasn't just the 4 shots, it wasn't just the heavy caliber or high caliber firearm with lethal ammunition. It was not knowing what threat, if any, he was faced with. He not only fired 4 shots, he not only did not offer a reasonable explanation for the reasons for his firing those shots. What he also does is, he is lucid enough to tell the court why he didn't fire a warning shot. And that he didn't fire a warning shot because he was afraid that it would ricochet. So there's all of these anomalies. And what it does say is, there's no reasonable explanation. But even if he thought in his mind that there was this intruder, there was no threat. He cannot tell the court then that even if I honestly, truly believe there was an intruder, this is the threat I faced. And so, Justice Bosielo, I am justified by firing not 1, but 4 shots. He could not tell the court because he did not know what the danger was, and he fired. And so it is
and
that...
this is not an ordinary firearm.
No,
we
it is
have
a
read
high...
the evidence what it does.
And what we say in that regard is, in using not just that type of firearm, if I may, while we're at that point, and I'll come back just to the grading of foreseeability, is that with respect, the fact that the respondent, Justice Bosielo, armed himself in the bedroom with a heavy caliber firearm with lethal black talon ammunition used for self-defense, which ammunition would mushroom on striking a soft, moist target, such as human flesh, causing devastating wounds. He then proceeded to the bathroom, ready to shoot whoever was in the bathroom. And on realizing that someone was in the toilet, fired 4 shots through the door at the person. That in itself, justices, negates the finding or suggestion that vulnerability and anxiety played a mitigating role in the commission of the crime. But the point is about the type of firearm. And let us not forget, this is an individual trained in the use of firearms.
Well, everybody's got a firearm, must be trained. You've got to go undergo training. You don't get a license without having a certificate that you are trained.
But the type of firearm and the type of ammunition says, I have an appreciation for. And so if we could just go back to the issue of the grading the degree of foreseeability, the only point I would want to make in dealing with the gravity of the crime is to say the following, justices. Although the absence of dolus directus may count in accused's favor, it is one of the totality of factors to be taken into account. A conviction on the basis of dolus eventualis does not per se constitute a substantial and compelling circumstance. It depends on the circumstances. The brutality of the crime, for instance, may militate against the finding that it is a substantial and compelling circumstance. This was found in the matter of the Director of Public Prosecutions, North Gauteng, Pretoria.
But let's forget about new sentences. We deal with this on a daily basis. A conviction on dolus directus, as opposed to a conviction with dolus eventualis, dolus eventualis is much lesser.
As the court pleases.
If somebody is charged with dolus murder and it comes down to couple of homicide, the sentence will be different. So that argument doesn't hold what it has to be different.
As the court pleases.
And that is why the legislature put it under section 51(2).
As the court pleases. And
section 51(2) doesn't make any distinction on whether the murder was as a result of dolus directus or dolus eventualis. Just says murder. If a dolus murder and no substantial and compelling circumstance, 15 years.
As the court pleases, and that is what we are saying, is that it is thus our humble submission that in grading the foreseeability, this court must please consider the brutality of the deceased death, and that it be so elevated that it could not and does not constitute a substantial and compelling factor. As a court
Do I understand your submission correctly, that your submission is that there is not a reduced blameworthiness?
As a court pleases, and would leave off the court if I could proceed and address that aspect, because that is exactly what we are saying.
Well, listen, that exactly what was said in State versus Banda. We use some of these things as normal incantation. The offense is serious, but you never put it in a context so that we understand how serious it is.
As a court pleases.
So what you're saying to us is that the circumstances of this matter are such that.
Yes, and that is what I'm saying. And I hear Justice Severity that when murder is murder, in terms of the Act on Minimum Sentences, however, I'm saying you cannot, without due regard to the facts in terms of the nature of the brutality used and the brutality of that crime, say, well, it's just dolus eventualis. And because dolus eventualis is lesser than dolus directus, well, then the sentence should be 6 years imprisonment. That is not where we're supposed to go to, as a court pleases. Justices, I just need to find my place. Sorry, Justice Pistorius. We deal with it as follows, Justice Mayor. We say that in misdirecting itself, in treating as a mitigating factor the respondent's alleged feelings of vulnerability and anxiety when he killed the deceased because he was on his stumps. We already referred this Honourable Court to its findings in its judgment in paragraphs 49, 53, and 54. And so I say, if we look at this court's findings in its judgment, in its appeal judgment, in those paragraphs, it defeats the argument that feelings of vulnerability and anxiety, Justice Mayor, reduced the respondent's moral blameworthiness. We say that one would expect the respondents to testify that it was feelings of vulnerability and anxiety which perhaps may have caused him to pull the trigger. But he says that he did not mean to shoot and does not explain why he fired the 4 shots. So we say, in keeping with this court's judgment, and if the court are quo, bore in mind the findings in paragraphs 49, 53, and 54 of this Honourable Court's judgment, there was no way that the court could have arrived at the conclusion that he had a reduced moral blameworthiness based solely on his vulnerability and his anxiety.
Well, there's no appeal against those factual findings. And even if there was, in terms of Rex versus Kumar, you wouldn't need to appeal with them. These are factual findings.
It is so. There are just 1 or 2 more aspects, if the court would allow me. We also found that the court misdirected itself in overemphasizing rehabilitation in comparison to considering the effects of deterrence and or retribution. And I think the court perhaps in misdirecting itself, and perhaps in the misdirection with regards to
If I recall
elevating.
correctly, you cited State versus Swap, which says in matters like this nature, retribution gets to come to the fore.
As the court pleases. That is so. And so we say that the court erred in law, that it was a material misdirection in finding that the accused respondent is a good candidate for rehabilitation, and that other purposes of punishment, although important, ought not to play a dominant role in the sentencing process. And this honorable court held in its judgment at paragraphs 58, referred to the matter of the State versus Vilakazi.
I think we've read that. We know that judgment is a judgment of our colleague, Judge Nugent.
As the court pleases, and if I could then only just make this point that in cases, not at the court, in the judgment itself, of Vilakazi, the honorable court held that in cases of serious crime, the personal circumstances of the offender by themselves will necessarily recede into the background. We have dealt with this in paragraph 6.13 of our heads of argument. Furthermore, Justices, we say in the matter of the State versus SWAT, as enunciated by Justice Bosiello, serious crimes will usually require that retribution and deterrence should come to the fore, and that the rehabilitation of the offender will consequently play a relatively smaller role. In this matter, we say the court misdirected itself in that it elevated the rehabilitation. And the second allied misdirection occasioned by the court was to find that because the respondent had successfully completed some prison programs, when he served his first portion of the sentence in terms of the culpable homicide conviction, he thus becomes a good candidate for rehabilitation. So we respectfully submit this is not the test in determining whether the accused is a suitable candidate. And if I may refer the court to the matter of Diante, State versus Diante, at page 552, paragraph 26, and if I may read, Justices, but it is, however, my view that seeds of rehabilitation can, in a manner of speaking, germinate only if the convicted person, him or herself, has first and foremost expressed contrition for his or her criminal wrongdoing, thereby accepting the gravity of the criminal act of which he or she has been convicted and commits to return to the path of rectitude. Without expression of contrition, any hope of rehabilitation becomes illusory and thus an unrealistic expectation and not merely a speculative hypothesis. And we say that is, in fact, the aspect in this matter. The first step to rehabilitation, State versus Van Rensburg. And State versus Van Rensburg tells us, Justices, at page 117, paragraph 7, in aggravation, it is so that the first step to rehabilitation is to acknowledge a wrongdoing committed.
Thereby showing insight and understanding of the wrong that you did.
As the court pleases. And the accused has not admitted his wrongdoing even after the conviction, and thus does not show any remorse. Ties in with the questions raised by Justice Severity earlier. And that is what I said, Justices, is that we have no explanation as well as no acceptance and perhaps an absence of an appreciation for the conviction of murder found by this honorable court.
Any other further submissions?
If I may just lastly just deal with the matter of State versus Martin, where it says to determine sentence, particularly just at page 176, Justices, right at the bottom at paragraph J, and I read, to determine sentence, particularly for a more serious crime, there is not a more important question than why did you do it?
What is the citation?
The court cases. State versus Martin, 1996, volume 1 of the South African Criminal Law Reports, 172. And I read, Justices.
Is it the judgment of this court?
Of Fleming DJP in the Witwatersrand
local division.
As the court pleases. And I'm at page 176, right at the bottom of the page, from paragraph J, and it will go over on to page 177, and if I may, with leave of the court, to determine sentence, particularly for a more serious crime, there is not a more important question than, why did you do it? It is hardly excusable to ask an accused how many children he has and to omit the crucial, why did you do it? Only in an exceptional case will the answer to that question not be dominant in getting to understand the influences on the accused and generally to discover the true degree of moral reprehensibility. With no known answer to that question, the accused is at risk of appearing to have acted without reason and to deserve the harshness which accompanies wanton criminality, which is executed without anything which reduces moral reprehensibility. An accused assumes some risk by failing to testify, in that there is then often a preclusion of opportunity to give an answer to that crucial question. Counsel's speculation without factual basis is thus not equivalent.
So the nub of your argument is, in the light of the circumstance of this matter, where the court struggled to find out exactly what possible reason could have led the respondent to shoot as he shot, you must find that he shot without reason. Because it's offered no possible reason.
Yes.
Thank you. And
the absence of that reason also goes back then to the heart of remorse. If I could then, to tie up, is to say that, and these are our general submissions, Justices, it is the applicant's respectful submission that the sentence in casu is so shockingly or disturbingly light that no reasonable court could have imposed it. This is so, having regard to a balanced consideration of all factors pertaining to sentence. The case, with respect, involves the brutal murder of an innocent, defenseless woman who had nowhere to hide when the shots were fired. The deceased still had a whole life ahead of her, but that was denied her by the accused in a horrific way. What perhaps makes the crime more apprehensible is that the killing of the deceased was senseless and/or gratuitous. No acceptable reason has been advanced by the respondent on why he killed the deceased. And the court could not primarily have regard to the mitigating factors or the personal circumstances of the respondent at the expense of the other elements and aims of sentencing. Such indeed has produced a warped sentence in the present matter. The Honourable Court in the matter of the State versus Lister, 1993, Lister, Justices, 1993, Volume 2 of the South African Criminal Law Reports, 228, it is an appellate court decision. And at page 232, paragraph end of G, beginning of H, Justices, the approach of a sentencing officer. Page? So, 228, and I read at 232. As the court pleases, paragraph, the end of paragraph G, Justice Severity, starting of H, and I read, the approach of a sentencing officer is not the same as that of a psychiatrist. The sentencing officer takes account of all the recognized aims of sentencing, including retribution. The psychiatrist is concerned with diagnosis and rehabilitation. To focus on the well-being of the accused at the expense of the other aims of sentencing, such as the interests of the community, is to distort the process and to produce, in all likelihood, a warped sentence. And that is our submission, that is what we have.
Can I recommend to you, as against that, was going to state as a SIEBERT, S-I-E-B-E-R-T. It talks about approach to sentencing by an enlightened court. State versus SIEBERT, S-I-B-E-R-T. I think it's a 1988 volume, I'm not too sure. It's an interesting judgment to read.
As the court pleases.
It proposed a new approach to sentencing.
As the court pleases. And part of the last portions then of our submissions is the Honourable Court also in the matter of the State versus Hewitt at paragraph 11 said, scrupulous care must be taken not to overemphasize the appellant's personal circumstances without balancing those considerations properly against the very serious nature of the crimes committed, the aggravating circumstances and the consequences for the victims and the interests of society. And if I may then, as a last matter, refer this court to the Director of Public Prosecutions, North Gauteng, versus Tabete, I'm sure, Justice Bosiello, you don't want to hear
I
this.
see you want to embarrass me. You
No.
want to see if I'm going to differ
On the
with what I said.
contrary, I say thank you, Justice. and at paragraph 12, if I may, and sorry, Justice, I have to bore you with your own judgment, but it is rather apt in our closing. And for the rest of the justices, please indulge our Justice Bosiello. First, he submitted that a sentence based on restorative justice, and although this, in this matter, is rehabilitation, say that based on restorative justice is not appropriate for such an offense, as it failed to reflect the gravity and seriousness of rape, particularly, and in this matter, it dealt with the rape of a 15-year-old. According to justice, the sentence imposed by the court below has the effect of trivializing the offense. And we do not want this brutal murder to be trivialized.
Does that public confidence in the system?
It does. It most certainly does. And thus the judgment goes on to read at paragraph 13 that the court below erred in overemphasizing the personal circumstances of the respondent at the expense of the seriousness of the offense and the interests of society. At paragraph 20, without attempting to lay down a general rule, I feel obliged to caution seriously against the use of restorative justice as a sentence for serious offenses which evoke profound feelings of outrage and revulsion amongst law-abiding and right-thinking members of society. And I think this court is very alive to the circumstances of the matter at hand.
Except that State President Hlagazi warns us against pandering to the public will. We've got to give public opinion, not be led by public opinion.
That is so. That is the finding of the court. And we are not asking the court to be led by, but in leading by, it says, I am mindful of. Yeah. And we say that the quota quo, in the quota quo, that is absent, that mindfulness of the public perception. And so my final quote in the matter, Justice Bosiello, is, it is trite that one of the essential ingredients of a balanced sentence is that it must reflect the seriousness of the offense and the natural indignation and outrage of the public. So in leading, we should have ensured that a different sentence was arrived at. And so we say, thus, that the quota quo misdirected itself.
Thank you, Ms. Johnson. Thank you very much, Ms. Johnson.
As a court pleases, if there's nothing else, I thank you, Justices.
Mr. Ru, I see it's almost tea break. Do you mind if we break for tea now and
Not at all,
reconvene at 11?
Thank you,
To
Justice.
give an opportunity to begin to reconsider the submissions that are copied.
Thank you.
Thank you.
matter, there were 3 points found to be compelling and substantial, because in inverted commas. And that was his relative youthfulness, he was 27. It was that he pleaded guilty. And that his legal representative during the proceedings through him tendered an apology. And of course, the Supreme Court of Appeal did not accept that and said that can never be compelling and substantial. So the point the submission I'm making, Justice Pistorius, that it is extremely dangerous to balance two cases, especially when they're so different.
Can I interrupt you? I think the flaw in the argument is to isolate remorse on its own without look at it in combination with other facts. That's not what the law says. You don't look at the fact and look at the fact. You take all of them together and ask yourself, do they amount to substantial and compelling?
Absolutely. But
and of course, cases will never be the same, because cases differ on the peculiar facts.
But in this case, it goes a step further. The criticism, and I'm responding, Justice Pistorius, to this remorse and regret argument. And the criticism was that, why did you do it, and why did you not take the court in confidence? Can I start with the starting point here? The whole case and the focus, and at least at the very minimum in the mind of the respondent, and I will from time to time make the mistake and refer to him as the accused because he was the accused, was that you, Mr. Pistorius, intended to kill your girlfriend, Ms. Steenkamp. And that was never out of his mind. And that was what he was protesting from beginning till end. And nothing changed in any finding, not by the trial court and not by the Supreme Court of Appeal in that respect, because the Supreme Court of Appeal had a very judicial finding on law where it said it does not help you to say that you thought it was an intruder and that you believed that Ms. Steenkamp was in a bedroom, because if you look at a law, that your error in persona would not exempt you from the dolus. But it's a very different dolus. It is not the dolus to kill your girlfriend. And that is, if you look at the evidence holistically.
But Mr. Roux, there is no explanation whatsoever why shooting 4 shots through that door into that little toilet cubicle. That is the state's argument. There is no explanation whatsoever. So how can there be remorse? There may be regret, of course. The consequences are dire.
Justice Mayor, with respect, I don't think that we can isolate the facts. And if I may just respond to it fully. And I will refer you, for instance, to one page. And there are many, and I annex the annexure of his evidence to theirs. But for example, 853, page 853 of the record, that is volume. I'll give you the volume number. It's volume 5 of 23. Right at the bottom, it says.
Just hold on. Volume?
Volume 5 of 23.
Page 853.
853.
Page 853.
853, Justice Seriti.
853.
Right at the bottom. And I will deal with the vacillation and try to put it in proper context. What he was trying to say. And there's this one missing element that's not argued, that's so important. And at the bottom of 853, where he was constantly criticized for calling it an accident. But we have to go to the layman's mind. And again, have to go to his mind, where his view is, I am blamed that I wanted to kill Ms. Steenkamp. And I killed her, but that was an accident. I never wanted to kill her. That's all he wanted to say. And then at the bottom, he says, what was the accident? You get right at the bottom of page 853. The accident was that I discharged my firearm in the belief that an intruder was coming out to attack me. Now, what he said consistently, and that one part he did not deviate on, it was not that he simply got up, walked to the bathroom, fired the shot.
Mr. Rowe, if you don't mind, can I intervene? With the greatest of respect, I don't understand why you are referring us to the record on that point. Because this court has already made a finding that we don't know what his version is. He did not explain why he fired the shot. It's a finding that has already been made.
Yes, and I'm bound by that finding, but I'm not deviating from that finding, Mr. Severity. What I'm trying to explain, we have to look at the immediate facts prior to the shooting. And where is that shooting? There was the problem when he said, it was fear, I discharged. But there's one important fact just before that we cannot ignore. And we cannot ignore it for compelling and substantial circumstances, to which I come back to. And that is, and what I'm trying to distinguish, he didn't walk to the bathroom and fire shots into the door. That he did not do. He was standing there.
But then another point, this court said that he has given contradictory versions. We don't even know which true version should we work on.
Yes, Justice.
Now, if at all they say he has given contradictory versions, how can we choose which version should we work on?
You cannot, but that's the next step. If I may just stop the step before.
Just on this step, look at paragraph 49 of this court's judgment.
Paragraph 49.
Paragraph 49 at page 3665.
Just
That's the judgment.
Where this court says, on his own version, when he thought there was an intruder in the toilet, the accused armed himself with a heavy caliber firearm loaded with ammunition specifically designed for self-defense, screamed at the intruder to get out of his house, and proceeded forward to the bathroom in order to confront whoever might be there. He is a person well trained in the use of firearms and was holding his weapon at the ready in order to shoot. He paused at the entrance to the bathroom, and when he became aware that there was a person in the toilet cubicle, he fired 4 shots through the door, and he never offered an acceptable explanation for having done so. And that is precisely what I'm putting to you.
Yes, but
why did he do that? We do not have an explanation for that.
Justice Meyer,
Forget about the deceased.
can I deal with this one point?
Yes.
And later we know what the evidence is, and that's that part. And when he became aware that it was a person in the toilet cubicle, that's one part that we cannot forget. What does that mean? And the evidence is clear. That evidence was never contradictory. That answer to that part. How did you become aware? He said, I heard a noise and I interpreted that noise of a person coming out. Up to there, it's absolutely consistent. It's his version from beginning. So it's not inconsistent with the judgment. I'm just explaining in that paragraph of this court's judgment, what does it mean when he became aware? He became aware when he interpreted that noise. That's what made him aware of a person coming out. Now, that is where the vacillation came in, when he said, I shot, no, I was fearful, I didn't mean to shot, I got such a fright. There was a vacillation. But up to there, it was not just walking and firing a shot. It was walking, standing there, first shouted for the person to get out. And when he heard that noise, that triggered the reaction. And he fired a shot because he interpreted it to be a person coming out. That's what it meant. The difficulty with his version was, now tell me, did you shoot him because you believe he was going to attack you? And there, he vacillated. It was, I was was fearful. I didn't mean.
Critical, Mr.
It is critical on one point, but at sentence, Justice Mayor, we cannot just take a line and say, now that this man, because on his fear and I didn't mean to pull the trigger, on that he vacillated. We cannot think what happened before away. We cannot think away that this man went to the toilet, shouted for a person to get out, not to go and shoot him. He wanted him to get out. He shouted, "Get out of the house."
You couldn't get out through that window. If you're in that bathroom, you can't get out through that window. It's a little fan light.
No, it's a side window.
No, that's the big bathroom, but in the lavatory.
No, not in the lavatory, but in the...
So how was he going to get out of the lavatory?
No, it was not at that time when he shouted. He did not know that the person was in the toilet. He knew that the person was in the bathroom. And that's a big window.
That's a big window.
Yes, that's a big window.
Then you could climb down the...
Yes, of course, and that's what he was shouting, "Get out."
Why didn't he say, "Get out or I'll shoot you"?
No. He said, "Get out of the
He
house."
never says, "I'll shoot you."
No, of course not.
Why doesn't he say that? Isn't that a warning? Isn't that a natural warning to an intruder if you're now not going to shoot?
Yes, if you look back with hindsight and perfect sight and vision, but Justice Lamont, if I may say, we can't think away certain factors that I will come to.
What burglar would slam the door, Mr. Rue? What burglar would come in and go into the bathroom and into the lavatory and slam the door?
Maybe when you heard the noise?
No, but he went in there and slammed the door.
It's maybe to hide. I don't know.
But what burglar would do that?
Some burglars will come and kill you, some will try and hide, some will run away.
He's putting himself into prison if he goes into that room. Any burglar who goes in that room who was outside will know that you can't escape through that window.
I can tell you that many cases...
And he slams the door, drawing attention to the fact that he's gone in there.
Because he's in a hurry, he's been detected. In the mind of the accused, he's been detected. Someone is now aware in this house is coming. That would be in the mind of the respondent. I've had many cases where the burglar did not escape when he could, where he was hiding behind something or simply lying down.
But
you get many different...
Slam the door, Mr. Rue. Let's just go back to that issue.
To the?
Slam the door issue.
Yes,
He wouldn't slam the door.
In his mind, we have to look at it through the eyes of the accused.
But we have to test what he says. We have to test what he says against an objective fact.
But that's a factual finding, and if it's rejected now on a sentence...
It wasn't rejected.
No, it was not rejected.
Correct.
So that's a factual finding that what he had was the slamming of the door.
Yes.
And that he interpreted to be that someone in the bathroom. And his mind was an intruder. That was his mindset. But I submit that we have to take it back one step and to see who is going to the bathroom. Because my reading is, and I don't believe that's wrong, of the Malgas decision and the Velakasi's decision, is not that you have this magic grounds for compelling and substantial circumstances. It is wide, and it leaves it to a discretion on the court. And what in fact says, if I may refer to the trial court's judgment with reference to Velakasi and to Malgas, it says, and she quotes that, it says, you take every factor into an account, not just what is more special. You look at everything, and there is residual discretion to decline to pass the sentence was given to the courts in order in recognition of the easily foreseeable injustices which could result from obliging them to pass the sentence. And in Velakasi it says, it consists of all factors relevant to the nature and seriousness of the criminal act itself, as well as all the relevant personal and other circumstances. And it goes on, it says, the more a court feels uneasy about an imposition of a prescribed sentence, the greater its anxiety will be that it may be perpetrating an injustice, and that once that uneasiness becomes a conviction, then an injustice will be done. And that is what the trial court did. The trial court said, let's look at this case. And the trial court was absolutely aware of the finding and the relevance of substantial and compelling circumstances. It is not that she was unaware of that. She then goes and she analyzes. And she says, And it's a holistic approach to a judgment.
But Mr. Roux, let's just stick to the point that you were arguing. And we were dealing with the question of regret and remorse.
Yes.
And the principle laid down in Mitigation is that in order for there to be sincere remorse, there must be an acceptable explanation.
Well,
That is the principle. And in this case, we do not have an acceptable explanation.
with respect, in the sentence context, I think we have with respect. And may I deal with the remorse element? Because it's not one single factor. It's composite. What does the accused explain? What did he explain? He explained that it's something that precipitated the shooting.
But Mr. Roux, I don't understand that point. This court clearly said that we don't know why he shot. And in the light of that, when the matter goes back for sentencing at a high court, the accused decided not to testify, despite the finding of this court.
Justice Severity, that finding and the way we read it followed when he fired the actual shots. It is not what precipitated the shots. Up to there,
No, but that is the point. Why shooting 4 times into a small toilet cubicle where there is no way out?
Justice Mayer,
Why imposing the death sentence to who he believed was an intruder?
Can I ask a question in another way? I'm sorry. We now know that the respondent gave different versions with which the court was not happy. Now, when you look at the judgment, paragraph 17, have a look at it.
Is it the trial court's judgment?
There's SCA judgment.
Just one. Paragraph?
That's 17.
17.
17. It's at page 3649. In what? Volume 21 of 23. Can I read it aloud?
Yes.
With ample justification, the court found that the accused had been a very poor witness. His version varied substantially. At the outset, he stated that he had fired 4 shots. The 4 shots, in quote, before I knew it. Another time when he was not sure of if there was somebody in the toilet. This soon changed to a version that he had fired as he believed, that whoever was in the toilet was going to come out to attack him. He later changed this to say that he had never intended to shoot at all, that he had not fired at the door on purpose, and he had not wanted to shoot at any intruder coming out of the toilet. In the light of these contradictions, one really does not know what his explanation is for having fired the fatal shots, an issue to which I shall revert in due course. There were other inherent improbabilities in version, some of which were mentioned by the trial court. Now that tells us that his version was not accepted. Now, why should you have recourse to that again? Because another court rejected his version. Whichever version you put across, the court rejected it.
Yes. All I'm submitting, Justice Severity, is this, that I'm bound by that action of shooting. There was a vacillation. I'm dealing with the facts immediately before it because you can't think that away. And that's what I wanted to deal with in the context of the remorse. When it came to the context of the remorse, it is true that he vacillated in the action of the shooting. Why did he shoot? He gave different versions. But we know there's something preceding that. And that was never in dispute. Where he said that, and for purpose of remorse, I'm going to explain it, that his actions was directed against an intruder, and when he heard that noise, that's when we don't know, he thought the person was coming out. I can only take it to there, because the rest I'm bound to. What did he then do to show if this person was satisfied with his conduct, and was it mere regret, or was it absolutely remorse? We have to look at the surrounding circumstances. And in his mind, and we know what we're dealing with, at the end, it is the deceased Ms. Steenkamp. And his mind, when he realized that, he was beside himself. That's not regret. That's far more than that. And he wanted them to help. And that evidence is given by objective state witnesses. Dr. Stipp. We take it a step further. He said it to Ms. Viljoen as well. But we take it a step further. Ms. van Schalkwyk was appointed at the bail application because of the condition of the the accused or respondent at the time. She says his whole concern was the deceased and the family. It was not about himself. That's confirmed by Dr. Hartzenberg. She says that was his focus, the deceased and their family. Before the trial, he tried to make contact. Understandably, they would not want to do that. During the trial, he tried to make contact. Understandably, it was in the process. After the trial, he tried to make contact. Understandably, they were not ready for it. But if you look at it composite and take it together, that's not mere regret with respect. That would be very unfair to say that's, you don't have remorse for what you've done. All I'm trying to say, it is difficult for the accused or the respondent to think himself out of the box and find himself in a situation where he's blamed that he wanted to kill Ms. Steenkamp because he did not, he protested that.
No, Mr. Ru, let us accept that he believed there was an intruder. The point which I have put to you is, why shooting 4 shots at the intruder through the door?
Now, if I may answer that question.
Yes.
We have to look at it to see who the accused is as a person. And we know certain things about him. We know that he has a serious disability. We know that evening he was not on his prosthetic legs. We know it was 3 o'clock in the morning. We know from all the experts that that disability over many years has a slow burn effect. They call it pervasive. We know as a child that his upbringing was to be overconscious and sensitive of crime. We know that he had a massive fear for crime. We know that he knew that when he was without his legs on, that he was absolutely vulnerable. And we know from Professor Foster, all of these are not in dispute. We know from Professor Foster's evidence that this man, in addition, has an anxiety disorder.
But
so,
in all that, I think there is all this that you are mentioning, they are mentioned in the record. In all those things, the question still is, why fire more than one shot? Not only fire one more shot, he has a very lethal weapon with him. It wasn't just a gun. So the question is why?
Yes,
that's the question.
I cannot stand here in view of the conviction and justify the 4 shots. What I'm trying to do is to explain the state of mind and say, look at that person. Maybe if I'm able-bodied and I don't suffer from anxiety, disorder, not normal, and I get there, I would be far more calculated and think better. But that person, in that situation, 3 o'clock in the morning, did not. He was just firing. It was not firing with that evil intent. It was his reaction as a result of who he was, of something that he had no control over. It's not the person standing there with confidence that feels that he can protect himself, that feels that he can run away. It's very different. And when we ask that question, why? I'm not, with respect, justifying the 4 shots. That I cannot do. And that was the reason for the conviction. But I'm trying to say, see it in its proper context, who the shots were coming from. Was it coming from this person that has so much confidence, so much reason to have confidence, so much ability to do something else, and it was not?
Would you allow me to ask you the converse of this debate? And I want to assume that Oscar reasons logically like any other person. He is sleeping, it's in the wee hours of the morning, he hears a noise in the bathroom, he knows that he is disabled, and naturally he gets scared. And he wants to find out what's happening. But in his mind, he's convinced it's an intruder. Let's forget about whether he knew it was Reeva or anybody. He knows there's an intruder. And he knows his life is at stake. He can't run away. He's got a firearm, he shoots at an intruder who is a potential danger to him, but he says, I didn't intend to kill. Now, when you look at the little kid, why would he shoot in that? I thought to say, I was in a desperate situation. I knew if this man comes in, I would not be able to run away from him. But not to stand here and decide I do not intend to kill.
Yes, just...
This is not just, it's not an ordinary fire, we're told.
Justice Bosiello, maybe just in the first part of your question, if I may refer you to Dr. Derman's evidence that was also not disputed. And that is, what you get, especially in persons with that disability, that they have an enhanced or an exaggerated fight response because they don't have a flight response. And they tend to go to the danger. And the accused, when he was asked, why did you go, he couldn't explain it because he wouldn't know about that exaggerated startle and fight response.
But doesn't that tell you with what I'm saying? Instead of the flight response, he had the fire response. Because if I don't fire now, this man might come out and kill me. But he says, I didn't intend to kill.
Yes.
I did not intend to kill this intruder.
But what he says is first was to put himself between him and the intruder, to put himself between the intruder and Ms. Steenkamp, because he believed she was in the bedroom.
I understand, yes, I understand that.
So what he did is going there was, in the first place, protection. Otherwise, if he just wanted to shoot, the shouting does not make sense. The pause, the standing there, does not make sense. There was more to that. So it was not an evil intent right from the beginning. And he was wrong. I'm not trying, he was wrong in firing the 4 shots. Whatever submission I make, he should not, and that was the finding. The question is very different. Can you just take the 4 shots?
With respect to you, I don't accept there's some version that the moment he woke up, he had made up his mind to shoot. I don't think that's how.
Yes,
I don't want to look at it like an armchair critic. Whereas I think then.
I understand that. That's why I'm thank you, Justice Bosiello. So what, the submission that I make, for purposes of sentence, he's been convicted. That's what it is. But for purpose of sentence, we cannot isolate. And the 4 shots are wrong. The 4 shots are wrong, but it cannot be isolated from the circumstances surrounding that. Who that person was and what circumstances at 3 o'clock in the morning.
But this precise argument, Mr. Roo, was already rejected by this court within the context of the conviction.
Yes, that argument
the
about
fact that he may well have fired without thinking of the consequences because of his disability and the like. Was absolutely in paragraphs 48 and 49 of this court's judgment rejected.
Yes, but the submission that we make, Justice made in the heads, because it was said, and correctly in the context of conviction, that if you look at his conduct, it cannot be rational. It was irrational conduct. We accept the irrational conduct. But when we come to sentencing, that finding of irrational conduct is not a guillotine that will cut out and destroy all mitigation and extenuation. That can never be so. Then you have to look at why was there irrational conduct? And that cannot be ignored. And there was irrational conduct that was explained. You sit with a person that's not like me.
No, but we don't have an answer for the irrational conduct.
But
we don't have an answer for that.
But you have for purposes of sentence.
What is the answer to that?
The answer is, if you look at that person, and again the last part of firing, was it fear, what did it mean? I don't have the answer.
That last part is the critical part, Mr. Roo.
It's not the end, it is one part.
Yes, but it is the critical part.
It is an important part, but I don't believe it's critical with respect. You have to...
To shoot 4 shots into, are you suggesting, to shoot 4 shots into that small little cubicle where there is no way out is not critical?
It is, of course, critical for conviction. It's critical as a factor to take into account of sentence, but it's not so critical that you draw a line through all the other aspects and you ignore the person and you ignore the circumstances of the person.
On that point, you say it's critical for purposes of marriage. It must also be critical for purposes of sentence.
Yes.
Because he's been sentenced for doing exactly that.
Yes, that is of course an important factor, and I'm not debating that, Justice Severity. But what I'm saying is it's so critical, and to use those words, that it would just delete and destroy all the other factors. And our submission is it cannot be. You have to look at that person who fired those 4 shots incorrectly. to be blamed and whatever. But who was that person and how did this come about? Would it have happened if that person did not suffer from all these disabilities and the slow burn effect? And that's what we submit to you. You have to look at it in the context of that. It's a very different person that we generally see. It's a person there whose control, whose understanding is seriously compromised, whose fear is seriously compromised, rightly or wrongly.
Mr. Roux, would it be fair to say that issue has not been exhausted? We've asked you all sorts of questions. Can you leave it to us to see how we deal with it in a judgment? I think we've all taken note of it.
I'm sorry, I didn't hear the last part.
I think this issue has been adequately debated.
Yes.
We can't take it any further than that. We've asked all of us all questions of that. You know what our thinking is. But let's leave it. Let's deal with it in a judgment. Are you comfortable with that? You can address
Yes, of course. Of course. I'm satisfied that it's before the court.
You can address any other issue.
But that takes it in a step further. And that is when the court, our quote, considered the compelling and substantial circumstances. Of course, she considered the heavy caliber, the 4 shots, the small toilet. But she says this, it's more than that. I also have to look at this person. I have to look at his situation. They all qualify in terms of Malchus and Vilikazi. They all qualify for substantial circumstances. And in her mind, a 15-year sentence, which is for murder, would not make sense. It would not, on the facts before her, be equitable. She experienced what firsthand what was going on there. She could see the emotions on all sides. She could see the pain on all sides. She could see the pressure on all sides. She could see the perceptions and the true facts. And she says, in that whole context, when I look at it, how can I impose a 15-year sentence where I get another person walking, he finds someone in his house and he shoot him 4 times. A normal, exactly the same sentence. It would not make sense that you give a sentence of 15 years, which is the minimum prescribed, to a person who fired a shot, he sees someone and he fires a shot in his house. In the day. And he shot him 4 times. In the toilet, wherever. As opposed to this person with the background that I don't want to repeat. As opposed to that, and it doesn't make sense. How can it be the same? How can they receive the same sentence? And that is where the court quoted the trial court. And she says, I referred to Vilikazi, and I referred to Malchus, and she refers to those parts where she says, when you as the trial court, in the exercise of your discretion, look at that, and it doesn't make sense to you, that where you feel it's an injustice, and she quoted those cases, and then what she did, she says, these are the circumstances, this is what I found, and it's clear from that in that she built in not only the aggravating, not only the 4 shots, not only the small cubicle, but also the person and the situation that evening. She brings it all together, and she says, therefore, because of what I've listed above, I find that there are compelling and substantial circumstances. She says, but it doesn't stop there. I also have to look further at aggravation, at mitigation. I have to look at the person before me, and then she carries on. And what she did not do, she was unfairly criticized to say, you just looked at rehabilitation. She did not. She says, I hear you about the rehabilitation, but it's not dominant. I must look at all factors. I must look at deterrence. I must look at retribution. And she did. She says that. There is, if you go through a judgment with respect, excuse me.
Can I read to you what the judgment says, Mr. Roux, and tell me if it accords with what you're saying to us? This, in my view, is an indication that the accused is a good candidate for rehabilitation, and that the other purpose of punishment, although important, ought not to play a dominant role in the sentencing process. Is that what our law says?
Yes, but it goes further than that.
No.
Yes,
that's I'm referring to this paragraph. Let's just deal with this paragraph which deals with the rehabilitation. Sorry.
She says...
Just hold on.
The question is that the law.
Is that what our law says?
I think that if you look at all the facts, the law may say, and I think the law tells us that you must balance all those aspects.
Isn't that what State Zing says? In the old case, he says that to us.
And I think that what you were saying, or not to play, she says dominant, she says I must balance them all. If you go to the top of 4023, she says the other purposes, mainly retribution, deterrence, are just as important and ought to be properly addressed. So if it comes across at the bottom that she's trying to water it down, she does not, it must be read with the top part. She tries to say that they're all as important. She doesn't want to give preference to the one or the other. And that's what she repeats again. And she says, what I'm not going to do, I'm not going to make the others more dominant. They should not be
With the
more
greatest of respect, Advocate, my reading and understanding of this paragraph is totally different from this.
Well,
it clearly says that, that the other purpose of punishment, although important, ought not to play a dominant role in the sentencing process.
yes.
In other words, the other purpose of sentence must take the back seat, and rehabilitation must take the front seat.
No, how I read it, Justice Reed, and then I again have to take up to the top part. I think what she was trying to say is that they must be considered equally. She says that.
But how can they be equal when someone's dominant?
No, she says I must not. Ought not to play a dominant role. What she's saying, I must not make retribution and deterrence dominant. And if you look to the top part, where she says, the other purposes, mainly retribution, deterrence, reformation, prevention, are just as important and ought to be properly addressed. If you read the two together, she was just cautioning that when you look at the factors, be careful not to make deterrence and retribution dominant. Treat them the same. She said
Is there no decision of this court which says that in case of serious crimes, retribution must play an important role?
No, but she gives it, but I don't believe that in every case, looking at the facts, that must be a dominant role. I think that my understanding always of the principles there is, make sure that you properly balance those principles. Don't give one more. In certain cases, of course.
In serious crimes, it must be.
Yes, but you have to look at the facts.
But then it's saying that in serious crimes, that's looking at the fact. For you to determine whether a crime is serious or not, you must look at the facts.
Yes.
In serious crimes, retribution must also play a very important role.
Yes, but I don't read paragraph 4023 that she waters that down. She just warns about the dominant role of that. That's all she does. And you see, what's so difficult is that, and I say this with great deference, and I want to refer you to a case.
Before you move on, isn't the law that when it comes to serious crimes will require that retribution and deterrence should come to the fore?
Yes, but I
Should
don't
come to the fore.
Justice Mayor, but I don't think that can be a blanket fact. I don't think that can be a blanket principle. I think every time that we look at those remarks and that approach, you look at the context of the case. It can never be isolated from the context of the case. Of course it's so. But you have to look at the context and you have to look at all factors. And to criticize with respect Justice Sipa because she worked under intense scrutiny. I really believe that she did very well. And it's in that respect that I want to refer you to the Manisi judgment on one point.
I'm sorry, okay. Talking for myself, I'm not criticizing Judge Masipa at all. I'm looking at what has happened, looking at the judgment, yes, and try and bring some sanity to myself. Yes. I'm trying to understand exactly what they're saying. And that is not criticizing the judge.
No, Justice Reed, but I'm just trying to say that if you look at it, and you look at the judgment holistically, and you look where she was coming from, then I think a lot of things can be justified, and you have to look at it and say, what is it that you actually mean? And it's in that sense, if I may just refer you to the Manisi judgment, it is, and I give you the citation, it's not in the heads. The Manisi one is D. Manisi, M-N-I-S-I, versus the state, and the reference is in square brackets 2009. and it comes from SAFLI, so it's the ZASCA. It's 17.
Can you come again with that citation?
It's ZASCA. It's in the Supreme Court of Appeal. 17, and I deal with Judge Maya, she then was with a dissent judgment, but on a different point. But the one point that's instructive is when you go to paragraph 18. She talks about when a judgment was criticized, and she says, regarding the first criticism, it is so that judgments makes no reference to the appellant's clean record and plea of guilty. But this hardly seems to me to justify a conclusion that the magistrate did not consider these factors in determining the sentence. As Davis AJA said some 60 years ago, in the quote, no judgment can ever be perfect and all-embracing, and it does not necessarily follow that because something has not been mentioned, therefore it has not been considered. To my mind, it is inconceivable that an experienced judicial officer, such as, in that case, the regional court magistrate, who daily adjudicates criminal cases, would have overlooked such elementary aspects on the sentencing. And I have no doubt that these factors would have weighed in the mind of the presiding officer. Now, what we say here, when you look at the judgment, excuse me, and when you look at it holistically, it is important to determine what weighed in the mind of the court. And there are two things that seriously weighed in the mind. The one was the fact of the aggravation, that he armed himself. She says that 2 places, that he armed himself with a high caliber, with ammunition, that he fired the 4 shots in this limited space. That's in her mind. In her mind as well is, but I have to look in context, and I understand. He was before me, I saw him. I understand what he said to me. Well, I shot out of fear that moment. I didn't mean that, and whatever. She understood it, she dealt with that. But she says, together with that, I have to look at the person. And then she looked and she repeats. She repeats basically what I've submitted to you on the vulnerability, on this person, his situation. And she says, when I look at that and I balance that, then I come to this decision. And I've quoted Vilakazi, and I've quoted Malchus, that I'm of the view that there are substantial and compelling circumstances. And she says that as such, and she lists that now in the sense as stated before. So she doesn't state it again. Now she's through that process. And then she says, but I'm not going to stop there. I've made now a finding within my discretion. And following Malchus and Vilakazi, that's not limited in the grounds. Now I'm going to see, now that I've found substantial compelling circumstances, what should be the appropriate sentence? And then she starts the process again. And she goes through the aggravation, the mitigation, factors to be taken into account. She even deals with the perception, but in a very different context. She deals with the perception to say, if there's a natural indignation by society, you must be careful. What is the indignation? Is the indignation because you believe A, or is the indignation because you believe B? And she says that when you look at indignation and the interest, you have to make sure that it's on the correct facts and not on perceived facts. That's all she was really saying. It's not a misconception of perceptions. She was just saying, when you look at a sentence, when you look at a situation, please don't look at it through a prism of perceptions. Look at it through a prism of facts. And what she then does, and she's mindful, this person was sentenced on culpable homicide. He was sentenced in terms of 2761I. She's now mindful of the following, that there's a change. It is dolus eventualis now. And she says, now I can't impose that sentence. I have now to impose a new sentence. But I have to take into account, and she says that, that he served time. She knows all these facts. What happened to him at the last moment when his correctional supervision is cancelled. It's all is what's happened to. She takes that into account. I'm sorry if I may just take a sip of water. And she says, I take all that into account. And I believe, because we know it's effective, the state starts off and say, sentence 6 years. The sentence is 6 years. But she says, I believe, taking this into account, that it's an effective sentence of 8 years would be appropriate. But I make it 6 years because he has served now, and we all know about parole, and we all know about the supervision. And she says, that's what I believe is an appropriate sentence. Now, to say in that regard, to say, well, that is such a misdirection, we disagree with respect. You look at the facts and you say, this man has done something that's terrible, because in the process of firing the 4 shots that he should not have fired, he killed someone that he did not want to kill. It's with him. She says he's going to be tormented.
He killed someone who he did not want to kill.
Yes.
Was he then prepared to kill an intruder?
I think if you look at all the facts and you look at the fear factor and you look at the problem, I think many people are, unfortunately, prepared to kill intruders when they feel there's a problem. But what we do know in the context of this, he never wanted to kill him.
Then there's no remorse.
No, but there is.
If he's prepared to kill the person inside, irrespective of who it is, then there's no remorse.
Yes, but
then his remorse argument falls away completely.
Justice
because his intention was to kill the person inside.
No, it was not. It was a dolus eventualis. It was explained.
Inside. Dolus eventualis versus whoever was in.
Yes, it was dolus eventualis.
And now he doesn't care who's in, and he doesn't have any remorse.
But he does.
Well, you just said he's prepared to do this.
If I may explain it, how can you have remorse against an intruder that's not real at the end? You know now it's not real. So how do I show humanly remorse to say, well, I just want to tell the court I have great remorse for the intruder? He can't have that, because by the time that we get to sentence, he knows there's no intruder. And his remorse must inevitably be focused on Ms. Steenkamp. And that's what he does. It's unfair. It's illusionary to have remorse as something that's not objective possible. Of course he doesn't have remorse.
Can I make a suggestion? In my view, at that stage, after this court has found that he has given various contradictory versions and he has failed to give an adequate explanation why he shot, when the matter is referred back to the Higher Court in Pretoria for rehearing, he should have got into the witness box and tell the court exactly why I shot that person. Because this court had already found that you haven't given us an explanation. And he failed to do that.
If we have to be practical, apart from the fact that his state of mind was given evidence about why he did not give evidence by Professor Scholes.
No, but the trial court rejected that evidence.
No, not that.
That he was not able to, that he needed hospitalization.
No, that's something else. She didn't reject that he was not able to give sensible evidence.
No, but if then he wasn't, as she rejected that he was as serious as made out by Professor Scholes.
To be hospitalized.
Yes.
Yes, that's what she rejected, nothing else.
No, but she rejected that he was as serious enough to be hospitalized. So why could he not testify?
But we tend then to connect hospitalized with the ability to give evidence.
Yes.
We think, and I disagree with that.
If he is not serious enough to be hospitalized, why did he not testify?
That I don't link hospitalization with a wonderful ability to give evidence. It does not wash away.
If the condition is not seriously enough to be hospitalized, why can he not testify?
Well, that's the evidence that he was in that state of mind that he could not do it. If it's rejected as false, I can do nothing about it. I don't believe it is. But let's look at it first. Now we say go into the box. What is he going to say? If he says, I fired the shots, Because I feared the man is going to coming out and kill me. He's going to cross-examine and say, but previously said you didn't know why. If he says, I fired the shots because I reacted without knowing, they say, but you lie because you have previously said that. It's an impossible situation. There is no way, with respect, that he can go on and survive any of that questions, because he will simply be taken. It's like a person who's made 4 different statements under oath. Now he goes and says, well, what must he pick? Must he pick now and say, well, let me tell to the court, actually, this whole story that I wanted to kill Ms. Steenkamp, that was true, I wanted to kill her and I have great remorse. That he couldn't do because it's not true. So what
in other words, he didn't testify because he was afraid that he was going to be cross-examined.
No,
can I just finish? About the various versions that he gave to the court. Should we accept that this is what you're saying? That he didn't testify because he gave various versions and was afraid that if he testifies, he will be cross-examined.
No, it is what I submit as a legal representative. I say to myself when I think, because that's the question that I'm confronted with. And I try to answer that question, and I think for myself, what would a person, that's not his state of mind, he wouldn't figure this out. How would he get there? But I'm trying to say, what is it that he should have done as a legal representative standing here today? So with respect, it's unfair, and you don't mean it that way to be unfair, but it would be unfair if I make that statement to say, well, that's what he thought at the time. You must also take into account there was evidence, undisputed, that he was suffering from severe post-traumatic stress disorder, and that was on the increase. That's post the conviction. That person, because that's a person that has all these psychological ailments, and that's what Professor Scholes was saying, and it was in fact confirmed in previous evidence by Professor Medal Foster. He's really suffering from severe post-traumatic stress. Now, there's that person with severe post-traumatic stress. He's standing there, and I try to see it for purpose of sentence through his eyes. He's standing there. He's in his mind foremost is, I killed my girlfriend whom I loved and I did not want to kill her. What must I do? I fired the 4 shots. What must I do? He's traumatized. He's tormented. What is it that he could do? Humanly speaking, there's nothing. And with respect then to criticize him, to say, well, A, B, and C, it's taking it out of that context who the person is and what he was suffering from. So it's not only that the difficulties I had before, but it's additional difficulties. And now he stands there, he's a sacrificial lamb. There's nothing that he can do. And to take that focus and to highlight that part in isolation is unfair, and that's why I keep on submitting. Take it holistically, and that's all the trial court did. She looked at it holistically. She was there right from the beginning. She lived through this case. And she says, if I look at this, who's this man in front of me? How is it that I'm going to punish him? If you tell that court that she, knowing everything, was fine, that there's no compelling and substantial circumstance, he must go to jail for 15 years. In that situation, with what he was suffering from, with that vulnerability, with the pervasive effect, it didn't make sense for her. And that's what she was trying to say. It's simply, and that approach, with respect, Justice Reed, is absolutely consistent with Malgas and with Vilakazi. It's not inconsistent. And I say it's that respect that we must move on and accept with respect that because substantial and compelling circumstances are wide concepts and not narrow concepts, then you look at the appropriate sentence and you see, is that shockingly inappropriate? And our submission to you is that you cannot replace one discretion with another. In her discretion, she mentioned all the factors. She says, I'm doing this balancing. I know of the horrible consequences. I look at the society. I look at the family. She dealt, in fact, if you go through a judgment, there's no need to point it out. She deals with every single aspect. And she exercises her discretion. And we submit that discretion was judicially exercised. It was not a discretion that she simply plucked from the air that is so inappropriate that it is shockingly.
The powers of the court appeal are clearly circumscribed. And the golden thread is that the discretion to decide an appropriate sentence rests with the sentencing court. And hence our powers to interfere are very limited. On the facts of this matter, why would you interfere with the sentence?
I submit, I've made a submission that if you look at it...
Sorry, before you go there, Malachas and Vilakazi put up their own standard of when a court of appeal can interfere. The usual epithet, disturbing, inappropriate, disproportionate. Why do you think this court should be able to interfere in this matter?
No, I submit that in this case, that if you look at the discretion, you look at all the factors. And when we come to sentence, it's not only, of course, a main portion goes to the merit. But it's more than that, where she says, look at what's happened to this man. Look what he's lost. Look at a family on the other side. She does that. It's a very careful balancing that she does. She looks at every single factor. I quoted Manisi to say how easy it is to leave something out. But she looks at every single factor. She does that balancing. And she says, I look at this, I look at that. And what is there to say that it was not a proper exercise of discretion? Maybe some court may feel, well, 8 years because it's a fact is not good enough, it should be 10 years or 9 years. But that's not a ground for interference.
But the law says express, we can't do that. It's not what sentence we think we prefer.
But that's the point, and that's the case law that we dealt with, Justice Pistorius, to say you don't have free range. And that's why I said now, and I meant well, it may have been misunderstood, Justice Severity, but I meant well. Justice Masipa, I don't think she would have asked for this case ever again. She went through a very difficult time. And if you look at the sentencing judgment, she was steadfast. She accepted the decision correctly of the Supreme Court of Appeal. In her discretion, she applied it to the facts, and she balanced the facts, and she comes to a decision. And that should not be interfered with.
Save for the fact that she did not expressly tabulate the factors that she considered. I mean, that they're in the judgment. What is the misdirection?
Yes, well, two things.
He dealt with the personal circumstances, he dealt with the nature of the facts, he dealt with public interest in the matter. They're in the judgment.
Well, two things. One, it's always, of course, better to list, but it's not a rule that you must list. I can tell you about so many judgments when you read it holistically.
That is why I referred to that paragraph where she's actually dealing with them. It's there in there.
Yes, what she says there, she says, I've taken all of the above into consideration. I'm of the view that the mitigating circumstances outweighs the aggravating factors. I find that there's substantial compelling. Her reason was what she says. I look at aggravation, I look at mitigation. She's dealt with it. I did that balancing act. And therefore I found that there's substantial and compelling circumstances. That is absolutely consistent.
So your submission would be leave to appeal should not be granted. There's no reasonable possibility.
I'm coming to that, but if I may make the last submission. What she's done there is actually what was said in Malchas. It's actually what was said in Vilakazi. And then the question is, on what basis should a court interfere with that discretion? Simply replace one discretion with another. I can understand in many cases. I would think, yo, that person gets 6 years. I think I would have given him 8 years. That's an inadmissible process. It is what's calling for a misdirection. What's calling for that absolutely shockingly disproportionate. And we submit there's nothing. And if that's not there, and if it's not sufficiently there, then we submit that leave should be refused. We argue the whole case, of course, for convenience and practicalities, but we believe that it's, in view of that a court should be loath, that's the case law over and over again, should be loath to interfere. You don't replace one discretion for another because it would just become, not a mockery, but it would become, I say to you, well, I don't think it's good enough, let's move on. There is a matter of certainty.
Well, we actually are warned as a court of appeal to avoid getting into a situation where we actually erode the discretion of the sentencing court.
And there's a reason for that. And the reason is not only discretion, but there's a great understanding over the years that sentencing court, many things you don't see on a transcript. Many things is not written down, but you see certain emotions. You see certain feelings. You live with that case, and it tells you in the inside what's right and what's wrong. And you can't always take that inside and write it down. And it's exactly what Vilakazi says. It says you get that, and when you feel it cannot be, it will be an injustice. And that's what the court did. It's that inside that it's not you. Otherwise, judgments would be pages and pages and pages, and every judgment would be criticized for not specifically saying A and B. Holistically seen, we submit that you exercise the discretion judicially, and we say that for purpose of this case, because it's first of all whether leave to appeal should be granted, it should not be granted, because it does not meet the yardstick.
But speaking for myself, as I read the judgment very carefully, I don't get the impression that he found 15 years to be so grossly disproportionate as to amount to injustice. No. She was just a little bit uncomfortable with 15 years. That's what came across to me.
Yes,
I don't want to play with words, but
yes.
Vilakazi talks about that feeling being so high, so strong, that it induces some sense of injustice.
Yes, well, it says, if I may read it, and it's in a judgment, where it says, the more the court feels uneasy.
I'm sorry, which page is that?
That's, if I may go to the judgment, page 4016.
Yeah. Now, I mean, the paragraph that we are reading is on which page? I'm
reading there from that she quotes the judgment, that's what I'm reading for.
Page?
4016 of Judge Masipa's judgment.
416.
4016.
4016. Thank you. Thank you.
Yes, it refers, it's Vilakazi referring to Malchus, where it says, the more a court feels uneasy about it, the greater its anxiety will be that it may be perpetrating an injustice. And that once that uneasiness becomes a conviction, then an injustice. And it became a conviction. She was.
Then you are entitled to depart from minimum sentences.
Yes. Yes. And that's what she says. She says, I weigh it up, and if you go there, if you go to 4019, she says, I've taken all the above into consideration. I view that mitigating circumstances outweigh the aggravating. That's what she's trying to say. And if you really paraphrase, what does she say? She says, how can I impose the minimum sentence if I come to the finding that there are serious mitigating circumstances? In her view, that's what it was. She took a holistic view. That's a view consistent with the case law. It's not inconsistent. And she's dealt with it. She doesn't repeat it again. What she then does, I think, is correct. She says, well, I go on now, and I deal with the balance of the mitigation. But I've come to that finding. There was a reason why she quoted those specific paragraphs in Vilakazi and Malchus.
Any other further submissions?
May I just approach?
Certainly.
May I just approach?
Yep, certainly.
Please. It's this one point that I think just should also be taken into account. This court in sentencing, she says, what do I have before me? What has happened now to this man? Because a man must be punished, and I know. But what's left of this man? She says, I look at the evidence. It doesn't come just from one person. We have
someone that described him as a broken man.
It's more than that. It's Hartzenberg explains it's not disputed, not at all. It's Pastor Nell saying that. It is Professor Scholes saying that, and Professor Foster. They say what's left of it, it's a broken man. Now, of course, that's another factor, and I've left that out. And the court would say, what is going to be achieved? And that's that case in the Sparks case that we quoted there, to say, are we going now beyond the point? He's broken, he's down and out. Let's punish him more. And that's a factor that Judge Masipa took into account. She says that. And she says, really, the wheels of justice is turned. It's wrong what's happened. It's terrible. And I think Justice Leach said quite correctly, it's of Shakespearean, I forgot the tragedy.
I had expected you to ask us what a sentence of 15 years would do, which a sentence of 6 years can't do, looking at the purpose of punishment.
Yes, but it's not only the 6 years. It's in fact 8 years. But
yeah, the 8 years that
it is because of the deterrence. It can serve no purpose anymore. He's gone. He's a man with his severe post-traumatic stress. He's tormented for the rest of his life. He's a broken man. But, and that's the point I was making now, Judge Masipa understood it's not only about the person. I understand it. But I have to go further. There is deterrence, there is retribution. You must be punished. And that's why I increased the sentence. Not from 1 year to 6, but in effect to 8. Because I know there's no purpose. There can't be any purpose. Nothing further can happen. When a man is broken, you don't break him more. But she understood the other principles also. And it's not only because you're broken that I can let you go. Otherwise, she give a suspended sentence. She still sent him in his condition to jail for a long time. He sat 1 year, he's gone through a long term of correctional supervision.
Doesn't Judge Nugent address that in the case?
Yes.
The gradation of the sentence
Yes.
from 10 to life.
Yes. And the court, and all I said, the only submission is that Judge Masipa took that into account. And if she was of the view that being broken is now good enough to walk out, you're scot-free, that would have been wrong. But she understood it's more than that. Although it would serve no purpose, she could not just forget what this has done. The consequences, and a lot of them brought onto himself, but a lot not. Where he was slated, where he wanted to kill his own girlfriend. She knows that. She had to address those perceptions. He was lambasted for things that were really not true. And she took all of it into account. And that's why she dealt with the public perception. To come around to the end and say, all I'm dealing with, I show to you. And if I may go to that page, and that would be the last submission there, it's at 4012. If I may refer to 4012, it's about line 8, where she says, she deals with all of this. Society has a right to have certain expectations and to demand justice. However, such expectations must be legitimate expectations before the court can take heed of them. It follows that expectations cannot be legitimate if they are based on wrong perceptions. And that's why she was dealing with it. So I submit, and we submit, that it was a very comprehensive judgment. She took everything into account. And she really exercised her discretion judicially. And in view of that leave to appeal should not be granted. I'm not arguing dolus directus because it was conceded. It's not an argument before this court. I've dealt with the moral blameworthiness in the heads of argument. I've set out case law. There's the Ferreira case. Why moral blameworthiness reduced is in itself compelling. And that's the Ferreira case there. And his factors, if you look at him as a whole, that is another factor that was taken into account by Judge Masipa. I don't know if there's anything else.
Thank you, Mr. Rue. Joseph, any reply?
If I may just start with perhaps the second last point, or the point raised by yourself, Justice Boseda, about whether or not leave to appeal should be granted. And just as you already have our arguments, but as a final aspect is to refer this court to the matter of the Director of Public Prosecutions of KwaZulu-Natal versus P. It is to be found at 2006, Volume 1 of the South African Criminal Law Reports at 243. And with leave of this court, if I may then only just refer to one paragraph, which is paragraph 10, to be found on page 250.
Page 250.
250, as the court pleases. What troubles is whether the sentence, and in this instance it was a postponed sentence, what troubles is whether the sentence imposed was appropriate in the circumstances of this case. The test for an interference by an appeal court is whether the sentence imposed by the trial court is vitiated by irregularity or misdirection or is disturbingly inappropriate. And in that paragraph, the court then also refers to the Rabi matter. And it says as well, even in the absence of misdirection, it would still be competent for this court to interfere if it was satisfied that the trial court had not exercised its discretion reasonably and imposed a sentence which was not appropriate. I can take it no further. It really goes to the heart of it. And just on one or two aspects, if I may, both with the appellant and the respondent, I think much was made about I am sorry or I am remorseful. And I think perhaps we should have pondered the point. Yes, the respondent apologized. What did he apologize for? I am sorry. I'm sorry for what? Family of the deceased, I'm sorry for your pain and suffering, for the loss I caused. Or family of the deceased, I am sorry that my actions at the end were found by the Supreme Court of Appeal to have intentionally and unlawfully killed the deceased, whether or not at the time I thought she was behind the door. And we still remain in a quandary. And if I could just refer to the record, we are at volume 12. And this is a sentence by the court quo when the respondent had been found guilty of culpable homicide. And it is at page 2235, going on to 2236, and I read at line 24, Justices. And it says, and this is the court quo, having found the respondent,
I'm sorry, which page?
2235, Justice Severity, of line 24.
24.
As the court pleases. And this is the court quo. The Honorable Justice Masipa, having found him guilty of culpable homicide. How much more relevant is this then not to a conviction of murder? And it reads, there was, however, a feeling of unease on my part as I listened to one witness after another, placing what I thought was an overemphasis on the accused's vulnerability. Yes, the accused is vulnerable, but he also has excellent coping skills. Thanks to his mother, he rarely saw himself as disabled and, against odds, excelled as a top athlete, became respected worldwide, and even went on to compete against able-bodied persons. For some reason, that picture remains obscured in the background. In my judgment, to get the real picture, the correct approach would be to balance the two. And we say that after this court found him guilty of murder dolus eventualis, there's no longer the balance. And the vulnerability becomes overemphasized. And to tie in with that, Justice Seriti, he did not want to tell the court.
I don't seem to have understood what you have said that. I mean, she acknowledged that now it's a check from the culpable homicide to murder by dolus eventualis. She attempted to show that by increasing the sentence, but unfortunately she didn't go to 15.
As the court
because she wanted a sentence that she felt was fair in the circumstances.
Yes, I understand that. And to tie in with the question, Justice Seriti, you know, he not only didn't tell the court, he didn't tell Professor Scholes, But just prior, and he's had his consultations with Professor Scholz, who's preparing a report to come and give to the court in lieu of mitigation for sentence. But he talks to the media. He does a television expose. So if you wanted to tell somebody, tell those to whom it is relevant. Because much ado is made about his victimization, for lack of a better word, in the media, his crucifixion in the media, by the media, and by the public. Yet when the opportunity arises, he doesn't make use of it. And to just touch the matter of Mnisi, it's a totally different matter. The accused in that matter pleaded guilty. He pleaded guilty to murder. And the difference between him and the respondent is the following. He admitted that he unlawfully and intentionally shot and killed the deceased. There's your difference. We do not have that.
Can I plead with you, we shouldn't go there? Because now you invoke in the Constitution. Is there anything wrong if you go to court, a church, and I use my right to plead guilty and put the state to prove everything?
As the court pleases, Justice Bosia, it's not about the pleading guilty. It is more about...
But that's a distinguishing factor between the two.
What I'm saying is that there's an admission of. And what I'm saying is, if we're looking at why we're before this honorable court today, it is the lack of an admission, and the lack of an admission in terms of acknowledging the wrong. And in acknowledging the wrong, perhaps we would not have a foot to stand on.
I'm still pleading with you, let's not go. You're going to confuse us.
As the court
I've heard this argument where the accused pleads not guilty, and at the end of the trial says, I was sorry. Listen, but why do you say you're sorry now? You plead not guilty when you started. I don't think those arguments are valid, particularly in the line of the Constitution.
As the court pleases, but...
I think you've made your point. Don't spoil your
No,
case.
as the court pleases. And then finally, is just to refer to we have referred the court to the DPP KZN versus P. I can take our arguments no further. Unless there's some other points the court would like to hear me on, I ask that the leave to appeal be granted, because I think we have made a case. I'm always surprised by counsel when they argue, particularly in this court, and they leave the judgments of this court and refer to the provincial division. I'm not bound by the provincial division, but you've referred, both of you have referred to State versus Hewitt. It sets out the parameters of the powers that you have. Yes,
none of you talks about it. Why did you give it to us?
We have referred to the matter.
Nobody never said about it today in your argument. And in my view, it sets out the parameters within which this court can interfere with the judgment of the court below.
As the court
very explicit, very elegantly written. In fact, it says, an appellate court may not interfere with this discretion, merely because it would have imposed a different sentence. In other words, it is not enough to conclude that his own choice of penalty would have been an appropriate penalty. That's what it says to us. It's not whether we think it was appropriate or not.
As the court pleases, but we have referred to the different case law, including the matter of Phillips, where this court is duty-bound. It's not I would, I could, I should have, maybe we can. This court is duty-bound, and I'm saying this court is duty-bound because there were misdirections. Based on those misdirections, this court thus has the power to interfere. And I stand by those submissions. As the court pleases.
Thank you very much. I think I will be dishonest if I do not express not only my views, but views on behalf of my colleagues, our appreciation for the manner in which you dealt with this matter. It became very clear that you had spent time on it, you take the seriousness of the matter, and you prepared well. Thank you very much for that. Because of the complexity of this matter, judgment is going to be reserved. It will come out in due course. Court shall adjourn.